Earlier this year, we passed the Workplace Fairness Bill. This was a significant milestone in our journey towards fair and merit-based workplaces. The new Workplace Fairness Act, or WFA, is a landmark legislation that strengthens protections for job seekers and employees against workplace discrimination. It complements the existing tripartite guidelines on fair employment practices, or TGFEP, by first prohibiting employers from making adverse employment decisions based on protected characteristics. These are nationality, age, sex, marital status, pregnancy, caregiving responsibilities. 4, race, religion and language ability. And 5, disability and mental health conditions. Secondly, it requires firms to have grievance handling processes to promote better communication and amicable resolution of workplace issues. And third, increasing the range of calibrated enforcement levers to strongly deter against unfair employment practices. As I had explained to this House when passing the Workplace Fairness Bill, we want to take a sure-footed and prudent approach to maintain the hard-earned harmony we have today in our workplaces and society. And this is why the WFA focuses on strengthening protections against the most encountered forms of discrimination, covering more than 95% of all of the complaints received by the Tripartite Alliance for Fair and Progressive Employment Practices, or TAFEP. We had extensive debates in this House over the scope of the law and how it meets the needs of the various stakeholders. Ultimately, I'm glad that the House was in unanimous agreement that the Workplace Fairness Bill passed in January is the right move to ensure that employees and job seekers in Singapore continue to be assured of fair treatment in the workplace. As mentioned in this House previously, the WFA will be introduced in 2 bills. The first bill covered the substantive rights and obligations under the WFA that I just summarized. And the second bill before us pertains to how individuals can make private claims under the Act. We have taken considerable time to work closely with our tripartite partners, the National Trades Union Congress, NTUC, the Singapore National Employers Federation, or SNEF, as well as the Ministry of Law and the Judiciary on the multifaceted processes involved. And I would also like to thank the many stakeholders who gave feedback, ranging from HR and legal professionals to non-governmental organizations, as well as members of the public. We have considered your views carefully, and the resulting dispute resolution process strikes a judicious balance between the needs of workers and employers. Fundamentally, we aim to provide an amicable, accessible, and expeditious dispute resolution process for parties in workplace discrimination claims while preserving our workplace and our social harmony. I will now cover how the bill will, first, encourage parties to resolve disputes amicably amongst themselves, including through mediation. Second, provide more workers with access to an affordable and expeditious forum to adjudicate workplace discrimination claims as a last resort. And third, include safeguards to deter and deal with frivolous claims so as to ensure a fair and a just adjudication process. Finally, I will also cover how we will support stakeholders in understanding and implementing this new law. Now, let me begin first by taking members through the dispute resolution process, which we have designed to bring about amicable resolution of workplace discrimination claims. Parties are encouraged to resolve disputes amongst themselves through the firm's internal grievance handling process. Now, if that is unsuccessful, the individual must attempt mediation with adjudication only as a last resort. The first bill passed in January introduced the requirement for all firms to put in place a grievance handling process for workplace discrimination. This allows employees and employers to settle their differences amicably while preserving the employment relationship. Now, notwithstanding this, we are mindful that not every instance of grievance handling within the firm will be successful. So the next step in the dispute resolution process is for parties to attempt mediation. Clause 36D of the bill sets out the requirement that claimants must attempt mediation before they can bring a claim to adjudication in the court. Mediation allows parties to have open conversations in a safe space to arrive at a mutually agreeable outcome, tailored to their respective needs. Now, we have heard feedback that workplace discrimination cases could involve complicated situations that are not as straightforward. So the mediator managing such disputes would need to be well-trained to facilitate the process sensitively. And we agree with the feedback, and I want to assure you that MOM will do its utmost to build up the capabilities of our mediators so that they have the requisite skill sets to mediate workplace discrimination disputes fairly and professionally. We have already started the work to uplift the capabilities of mediators at the Tripartite Alliance for Dispute Management, or TADEM, to prepare for the WFA. Today, TADEM mediators handle a range of employment disputes of up to $30,000. We will further strengthen the capabilities of TADEM mediators so that they will have the skill sets and the competencies to navigate workplace discrimination claims when the Act comes into force. This includes customized training programs to equip them with varied mediation approaches to deal with complex workplace discrimination disputes. Coverage of inclusivity and sensitivity training to better serve a range of individuals, including persons with disabilities and persons with mental health conditions. We will also appoint other mediation service providers, such as the Singapore Mediation Centre, to mediate higher value claims above $30,000. We will set more stringent requirements on mediators for higher value claims, including possessing legal qualifications or having the relevant experience mediating employment disputes. These measures, I believe, are crucial so that the mediation process is robust and that it effectively resolves disputes. Finally, the option of last resort. Now, if parties are still unable to come to a resolution amongst themselves after mediation, an individual can commence a workplace discrimination claim at the Employment Claims Tribunals, or the ECT, or the High Court, as stipulated in Clause 36A. Now, let me now set out how we have designed the adjudication of workplace discrimination claims. We want to avoid workers and employers being embroiled in lengthy litigation, often associated with high legal costs for both sides. We have therefore designated the ECT to be the main forum to hear workplace discrimination claims. This provides more workers with access to an affordable and expeditious dispute resolution forum to seek redress. Now, Mr. Speaker, Mr. Deputy Speaker, sir, for the benefit of members who may be unfamiliar, let me elaborate on how the ECT works. The ECT was established in 2017 to hear employment claims up to a claim value of $30,000. It adopts a judge-led approach with simplified rules and procedures, and legal representation is not allowed. Parties should find it easier to navigate the ECT's simplified process with the judge's proactive approach, compared to the process in the civil courts that is governed by formal procedural rules and where parties have to take the lead in proceedings. Now, without the need for lawyers in the ECT itself is also more accessible to individuals who might otherwise be unable to pursue legitimate claims due to financial constraints. With these unique features, the ECT provides a more affordable, expeditious, and easier to navigate alternative to the civil courts. For instance, most cases at the ECT are resolved within 6 months, while employment-related cases in the state courts are resolved within 18 months, about 3 times more. Now, let me explain what the claims process looks like in practice. Judges will actively lead the proceedings by directing parties to speak, asking questions to gather relevant facts, and making it clear when issues raised by parties are out of line and irrelevant. After each party has presented their case, the judge will consider all the facts and relevant evidence given by the parties before making the judgment. Overall, this is a far more outcome-oriented and expeditious process. To make the ECT's affordable and expeditious adjudication process accessible to more workers, we will expand the ECT's jurisdiction to hear workplace discrimination claims up to and including $250,000. Now, this mirrors the limit for civil claims heard at the district courts. The expansion of the ECT's monetary jurisdiction does not mean that we expect workplace discrimination claims to be of a higher value than other employment claims today. Instead, the intent is to allow for the vast majority of workplace discrimination claims to be heard in the ECT. The higher limit ensures that the majority of workers, including PMEs who earn higher salaries, can access the ECT's more affordable and expeditious process for workplace discrimination claims. The higher claim limits will only apply to workplace fairness disputes and not other types of employment claims, such as salary-related claims and wrongful dismissal. Workplace discrimination issues, they are inherently sensitive and they can be socially divisive, especially when they concern matters such as race and religion. Designating the ECT as the main forum to hear workplace discrimination disputes will provide a less adversarial setting for such claims to be resolved, preserving our workplace and social harmony. Now, while we've strived to make the dispute resolution process accessible, we recognize that some parties may still require guidance through the process. I would like to assure our workers and employers that additional support is available to parties who may need it. First and foremost, TAFEP remains the first port of call for workers and employers who need advice and assistance on workplace discrimination. For instance, TAFEP can guide claimants on the criteria for a WFA claim, direct them to the relevant guides and resources, and outline the options for them. In addition to TAFEP's advice, unions can also help their members, both workers and employers, and union representatives can represent parties at mediation sessions and ECT hearings. Workers may be represented by their union per the status quo for ECT proceedings today. Unionized companies can now also be represented by their unions, such as SNAF, for claims between $30,000 and $250,000. And if the worker filing the claim can also be represented. So, in other words, the union for the employers can represent them if it's above $30,000 up to $250,000, but only if the worker filing the claim can be represented. This is a new feature for employers who currently cannot be represented by their unions in the ECT, as they may need support for higher value claims. Now, I've outlined how claims up to and including $250,000 will be managed at the ECT. For higher value claims above $250,000, these are better heard by senior judges on the High Court bench with legal representation. Now, this is also the case for other types of high-value employment claims today. I do not expect many workplace discrimination claims to be commenced in the High Court. Given the inherently sensitive nature of workplace discrimination disputes, all workplace discrimination claims, whether in the ECT or the High Court, will be heard in private. This means that media or members of the public cannot attend the hearings. Private forums create a safe environment where parties can share their honest views and focus on the ongoing case, without third parties present who may publicly misrepresent and sensationalize issues, resulting in inflamed social tensions. This process protects the reputations of both the workers as well as the employers. Finally, Clause 36E also sets out specified time bars within which individuals must submit the mediation request to initiate their claims. These time limits typically vary from 1 to 12 months, depending on the claimant's circumstances. Time bars encourage individuals to come forward earlier before the evidence degrades over time. And it also provides our employers with some certainty that incidents from the past will not be dredged up years later. We believe this is a balanced approach as it is practiced for other employment disputes and in other jurisdictions as well. Now let me move on to the third part of my speech, which covers the safeguards to ensure a fair and just adjudication process. In our public engagements, we heard a concern, particularly from employers and HR professionals, about the risk of frivolous and vexatious claims and of unreasonable inflation of claim values. Let me take some time to address these concerns. To be clear, individuals with genuine cases of workplace discrimination should be able to seek redress. However, frivolous and vexatious claims weaken our workplace harmony, and employers should not be burdened by such claims. Employers will be able to apply to the judge for frivolous claims to be struck out. Judges will also be empowered to strike out claims on their own motion and can award costs against an individual who pursues a claim that is without merit. In addition, individuals filing such claims can be investigated by the police for abusing the court's processes. And if they persist in raising unmeritorious claims, they can be restricted from commencing further legal proceedings. We also heard feedback that with the increase in the ECT's jurisdiction, there is a risk of claim amounts not being pegged appropriately. Workers may not know how to go about justifying their claim amounts, and employers may be concerned about unnecessary inflation of claim values. MOM will work with tripartite partners to explore ways to address this in the implementation. Claimants will still need to prove their losses to justify the damages claimed, and judges will also make a fair and balanced assessment of the reasonableness of the claim amount. Let me move into the final issue, which is the implementation of the WFA. When we moved the Workplace Fairness Bill in January this year, I had at that time said that the Act was expected to come into force in 2026 or 2027. Now, we have heard feedback from various stakeholders. MOM recognizes that ample preparation is critical for successful implementation. Employers need to review their HR processes. Workers need to know their protections and what constitutes a legitimate discrimination claim. We will also need time to ensure that our mediators are well trained to effectively facilitate workplace discrimination cases. As such, we currently target to implement the Act in end 2027, but we will continue to monitor readiness of all parties and adjust this timeline as necessary. In the meantime, we will step up our education and outreach efforts TAFEP is working closely with partners such as SNEF, the Institute for Human Resource Professionals, or IHRP, Singapore Human Resources Institute, and the trade associations and chambers, such as the Association of Small and Medium Enterprises, to educate employers on the new legislation. TAFEP will also proactively reach out to SMEs to ensure that they are aware of their responsibilities. In addition, TAFEP is also designing step-by-step guides and templates that SMEs can easily access, understand, and customize for their needs. There are also resources such as briefings, clinics, a webpage housing information on fair employment practices, and HR e-learning modules that companies can incorporate into their own in-house corporate training, just to name a few. It's just as important that individuals are also aware of their rights and where to seek help. So we will provide guidance to job seekers and employees on what matters can be raised as a workplace discrimination claim. This includes ensuring individuals know where to turn to for help. For instance, within their firm, their unions, or to TAFEP. To make the Act simple to understand and apply, we will also develop a handbook to capture the legal provisions and the key principles behind the law, for instance, through illustrations and case studies. The Workplace Fairness Act, as I've shared in the past bill, is not a panacea to resolving workplace discrimination. Notwithstanding this is a significant step in our ongoing journey towards fairer and more harmonious workplaces. There's no room for discrimination in our workplaces. When such cases unfortunately arise, we want the parties involved to be equipped with the necessary tools and resources, which will then allow them to resolve the issue amicably and expeditiously. The model that we have carefully designed enables workplace discrimination issues to be discussed and to be resolved quickly while ensuring just outcomes. In doing so, we aim to preserve, reinforce, and improve all of our existing norms on fair and harmonious workplaces for all. Mr. Deputy Speaker, sir, I beg to move.